In this video, I'll be discussing Bridgeport Financial. Hi, I'm Consumer Protection Attorney Bill Clanton, and I've helped hundreds of people deal with debt collection harassment, inaccurate credit reporting, and other consumer-related matters. At the end of this video, you'll know who Bridgeport is, what they do, and how you can protect yourself from them. Bridgeport Financial is a San Jose, California-based debt collector. They have a bond on file with the Texas Secretary of State, so they are a legitimate bonded debt collector. They were established around 1994, so they've been around a while. And they have complaints with the Better Business Bureau, about 7 or more. No complaints with the Consumer Financial Protection Bureau. And according to federal records, they've been sued at 18 times for violations of the Fair Debt Collection Practices Act. Now, Bridgeport isn't focused on a particular type of debt that they collect. They collect medical debt and other consumer-type debts. But they are regulated by the Fair Debt Collection Practices Act, the Telephone Consumer Protection Act, and the Fair Credit Reporting Act. These 3 laws are powerful, provide powerful protections for consumers. I'm going to start with the Fair Debt Collection Practices Act and how Bridgeport violates the act and what they're prohibited from doing. Bridgeport cannot call you and harass you, intimidate you, threaten you into paying. Any threat that they cannot take or do not intend to take, but they still make, it's a violation of the law. Bridgeport can't call you and harass you. They cannot be obscene or profane in their collection attempts. If Bridgeport's going to give you amounts or discuss the status of the debt, they have to be honest with you and non-misleading. They cannot make a misrepresentation about the legal status of the debt, the character of the debt, or the amount of the debt. If Bridgeport says that an attorney's talking to you, it must be an attorney who's familiar with your case and your file. If Bridgeport is reporting on your credit report, they have to report accurately and completely. And if you dispute the debt with Bridgeport, then they have to report it as disputed. Bridgeport can't add fees or costs or anything else to the debt unless the original contract provides for that. Now, at the outset of the collection of consumer debts, debt collectors like Bridgeport have to give you the G notice, what's contained in 1692 G of the FDCPA. The G notice says that as part of the initial communication, or within 5 days of the initial communication, a debt collector has to send you in writing, that can be by email or by regular mail on paper, a notice that gives you the amount of the debt, the name of the current creditor, gives you a notice about your ability to dispute the debt, to request verification of the debt, and to request the name of the original creditor. Sometimes debt collectors take liberties with this notice and try to give their own spin to it or their own interpretation, and it turns into being something more or less than what's required by law, and this can be misleading. In fact, any communication, whether it's by the phone or in writing, can be misleading, and it's important to keep copies of any letters you get from Bridgeport. Sometimes a letter is misleading, but sometimes 2 letters, when you look at due dates and amounts in 2 different letters, they may not agree, and this can be misleading. Also, make note of any amount they tell you over the phone and any amount they're reporting in your credit report. Oftentimes these amounts do not agree, and if they don't agree, then one of them cannot be correct, and this is a misrepresentation, actionable under the FDCPA. Another law that I mentioned is the Telephone Consumer Protection Act, the TCPA. The TCPA says that if Bridgeport is going to call your cell phone or text you with an auto dialer, they have to have your permission. If they don't have your permission, it's a violation of the TCPA. A violation of the TCPA entitles you to damages of $500 per violation. So each call or text you get in violation of the TCPA, the damages are up to $500. Additionally, if you can show the calls or texts were made knowingly or willfully, then you can get up to 3 times that, or up to $1,500 per call or text. Save your phone records, save your text records, because these cases can the damages in these cases can add up very quickly. The third law is the Fair Credit Reporting Act. Under the Fair Credit Reporting Act, Bridgeport must, if they're going to engage in credit reporting, they must do it accurately and completely. If it's not accurate or complete, you have the ability to dispute their reporting. You can dispute it with Bridgeport directly, or with Experian, Equifax, and TransUnion, or all four, excuse me. In this dispute, you can lay out why it's inaccurate or incomplete, and they have to investigate it. Each of them has to investigate it and get back to you. If the information is not corrected after you dispute it, then you may have a claim under the Fair Credit Reporting Act. These are three powerful federal laws: the Fair Debt Collection Practices Act, the Telephone Consumer Protection Act, and the Fair Credit Reporting Act. They ensure that companies like Bridgeport treat you fairly and do not damage your reputation. Having an account in collections is no fun, but I want to help you out. I can level the playing field between you and Bridgeport. Our office has the experience, the systems, and the know-how to bring claims against Bridgeport and to level the playing field for you. If you're ready to turn the tables, give us a call. We only get paid when we recover money for you. We don't charge anything for a case evaluation or to get a case on file. So give us a call, 210-226-0800. And thanks for watching.